So unless you
Standing,
have...
I don't understand, or I don't comprehend standing. It's a simple question, Your Honor.
Well, I used the exact same words you used to me, so I suspect that you do understand. You said that your question still stood. I said my answer still stood.
Okay.
So they're the same question, the same answer we've done every time.
Is your capacity, are you addressing me other than the beneficiary?
As I've never addressed you as the beneficiary.
Okay, all right. Well, for the record, on the record, let the record show, I am here as the beneficiary. I'm only here as the beneficiary. I'm, in fact,
there is no beneficiary capacity that
to
you
this
can
capacity.
have in a criminal court case, Mr. Wilson. We've done this, which is why you have standby counsel. I continue to be extraordinarily concerned based on the position you're attempting to take. This is a criminal courtroom. There is no contract law here. There is no beneficiary law here. There is nothing of that nature. I remain a neutral magistrate set to govern the rules and the procedures in a criminal case in which there are two parties, one of which is the state and the other of which is you. You have counsel. Talk to your counsel, please, because I think it'd be in your best interest. I remain continually concerned. So I understand that you want to take the position that you're taking, and you have a right to represent yourself, and you may proceed down that line. I continue to be very concerned with regard to your position.
Are you still offering the jury trial?
The jury trial is set and will take place on July 12th.
So you are still offering that then?
We're still having that.
Okay. Well, for the record, on the record, let the record show, I have no constitutional benefits or rights. I want no constitutional benefits or rights. I claim constitutional benefits or rights. And your offer is very generous, Judge Christopher. However, I do, in fact, waive your benefit offer of a trial, jury, or by a judge or any other manner. The question belies you. Are you going to settle and close this as you have been instructed, demanded, and release the surety to the state in honor?
None of
or
those
in
concepts have any place in a criminal case. And my concern continues, sir. You are accused of a serious crime, a serious offense, for which you can be incarcerated for a significant period of time. And you have the right to represent yourself. I have done everything I can figure out to do to make sure, one, that you understand what the process here, which allegedly you do, and two, to make sure that you have legal counsel available to you. But my concern remains that this matter will not be closed, nor will any other action take place in the manner in which you are suggesting. We will proceed to a jury trial unless there's a reason. The state has an equal right to a jury trial. Ms. Cole-Hodgkinson?
Your Honor, listening to the defendant, I don't think this is the interpretation, but could you inquire of the defendant if it is his intention to change his plea?
Well, and that was going to be my next question. With regard to you indicating to me that you wish to waive your constitutional rights, and you wish to waive your right to a jury, and you wish this matter to be closed, is the court to interpret that statement as a plea of guilty to the criminal charges that are pending against you, sir?
There are no wishes involved in this, with all due respect here. I have instructed and demanded that the trustee, Judge Newton, settle and close all obligations to this matter as of the 20th May hearing.
And you have provided no legal authority for your request. I have no position to take that kind of an action in this matter. The resolution of a criminal case is by either a plea of guilty or by a plea of not guilty. If you are guilty of the charge and you are satisfied to understand your constitutional rights and you wish to waive them and enter a plea of guilty, then the court will certainly accept that. But if you wish to maintain your position that you are not guilty of the criminal case that's pending against you, you have a right to take that matter to trial and to have a jury determine your guilt or innocence after the state has been required to prove the case they have against you by beyond a reasonable doubt. And that would require the state to satisfy their statutory burden. That would require them to present present witnesses. That would require them to allow you the opportunity to confront those witnesses. That would require that you could call witnesses on your own behalf, that you could in fact testify if you wish to do so, but you have an absolute right to remain silent. You have all of those rights. You have told me this morning that you wish to waive your constitutional rights. Does that mean, sir, that you are now saying that you are guilty of the charge that pens against you, of all of the charges that are pending against you as outlined in the amended information filed February 12th, 2010?
I am just the beneficiary here.
You
I
are
am
not the
only the
beneficiary.
beneficiary
You
in
are a
capacity.
defendant, sir. You are not a beneficiary of anything.
I am
Except your
only appeared as
constitutional
the
rights.
beneficiary. I am only in that capacity. I am in fact the only contributing beneficiary to the all capitalized spelling of the entity, BRENT-ARTHUR-WILSON. Does this courtroom, Judge Christopher, prosecutor, do you have any evidence to the contrary? Any?
There is no position that can be taken of you stand charged with a criminal offense. Is it the state's intention, then do you wish to proceed with a jury trial and exercise the state's rights with regard to a jury trial?
Your Honor, you advise the defendant that he has the right to plead not guilty and represent himself. He has the right to plead guilty. Would you, could you explain to him what a no contest plea would involve?
To the limited extent that I can accomplish this from the bench, you do have the right to plead nolo contendere, to plead no contest to the charges that stand against you, which include theft of felony, deceptive practice as a felony, tampering with public records or information of felony, criminal mischief, a misdemeanor, and false swearing, a misdemeanor. If you plead no contest, what you would have to acknowledge is that you have reviewed what it is that the state has, that they believe they can prove against you. And in your review of that information, you believe that if the jury sat and made a decision on this case, that it is likely that they would find you guilty. And you have to acknowledge to the court that you believe it is in your best interest to plead nolo contendere and to accept whatever recommendations the state has in this court's sentence in this matter. So there has to be a factual basis that you believe exists for the plea of guilty and that it is in your best interest. You may do that as opposed to pleading guilty in this matter. The result of a nolo contendere plea or a no contest plea is a guilty finding, a conviction under the criminal law of the state of Montana.
Thank you, Your Honor. With regard to your question about whether or not the state wanted to exercise its right to a jury trial in this case, if Mr. Wilson is willing to waive his right to a jury trial, then the state would also waive its right to a jury trial.
Mr. Wilson, back to you, sir. Do you wish to have a jury trial on this matter, or do you wish to waive your right to a jury trial?
First of all, I am the beneficiary, and I'm only speaking in the capacity of the beneficiary. I am only here as a beneficiary. In regards to your offer there, that is a detail and an obligation of the trustee judge to close and settle. I am just